made just to guide people about certain principles of law. Because I just saw that on YouTube there are not sufficient legal knowledge provided to the general public. We'll try to put forth certain issues which are very common in litigation. In this first episode, we are starting with divorce, because I have seen that in India, divorce, the litigation related to divorce matters are creeping up like anything. So what is divorce and how the decree of divorce can be taken? Now there are two types of divorce available to Hindus. Now we are talking about Hindu law. So any two Hindus got married, whether before 1956 or after, because there was a litigation implemented in 1956. So I am saying whether before 1956 or after, can take divorce by two methods. Now the most simple method of taking divorce under Hindu law is taking divorce with mutual consent. Now what does this mutual consent mean? Mutual consent means when husband and wife have agreed upon certain terms and conditions and they have decided not to continue their marriage, they can file a joint petition. This is the easiest form of divorce, and I would like to say that if you go for taking divorce with mutual consent, you are going to save a lot of time, you are going to save a lot of other legal formalities, you are going to save your face in the public, because this is a very quick procedure in India. Now, in case of mutual consent divorce, you have to file a joint petition. A petition is drafted by the lawyer. He will describe all the terms and conditions. In that petition, what are the terms and conditions of divorce are to be written, like what will happen of maintenance of wife, permanent alimony, monthly expenses, everything is written in there. If any expenses or gifts were given at the time of marriage by the bride to the bridegroom side, what will happen to those gifts and all the expenses incurred by the bride side. Everything is to be written in that joint petition under mutual consent. What will happen to any issue, like if they have got an issue, boy or girl, to whom that boy or girl is going to reside, and what will be the rights of other person, whether he or she will have right to visit him, or he will not have those rights. Everything is written in black and white. This joint petition is then submitted to the court. Both parties have to be present in person at the time of filing of this case. The judge will examine the petition, the correctness of allegations. There will be no allegation as such in the petition of joint mutual consent divorce, and he will just examine whether these people were actually married, their identity, and the reason of divorce. Now the purpose of Indian courts is to join the families and not to break them. So every court has the duty to try to not to break the families by any divorce petition. They try to reconcile the matter between husband and wife. So every petition is then sent to reconciliation centers. Reconciliation centers are sometime out of the court, and sometimes they are just behind the court, made in rooms separate there. Two or three people are engaged there by the court. They must be a reputed person of society. One of them happens to be female, I would like to mention, and they try to sort out what were the differences between husband and wife. They try to sort it out. However, if this reconciliation proceeding fails, then the matter will again come to the court, and the court will write down its statement that the reconciliation proceedings have failed, and in case of mutual consent divorce, the next date will be of 6 months. The parties are given time to reconcile their disputes, and they are asked to come after 6 months. When they come back on after 6 months, if their disputes are not resolved and they still want to continue their petition of divorce, then the court records the statement and grants a decree of divorce. That's the final thing. So this is the easiest form of divorce in Indian law. The other form of divorce is not by mutual consent and by making some allegations. How many type of what are the conditions under which you can take a divorce? First of all, it is yes, that if either of the spouse has solemnized another marriage, this is one of the ground of divorce. Either he has solemnized another marriage with any other person, or he had voluntary sexual intercourse with other person. This is the most important ground. But in this case, it is very difficult to prove the factum of having voluntary sexual intercourse with other person. The other reason that he had solemnized the marriage is easy to prove, but this second factor is a bit difficult. So one has to be very cautious taking this ground. The second reason for taking divorce is that after the solemnization of marriage, either party has treated the spouse with cruelty. Now, this is very important point. 90% of the cases of divorce are filed on this ground alone. Now, cruelty includes physical cruelty as well as mental cruelty. Even abusing is taken as a ground of cruelty. Abusing the spouse, his family members, his or her family members, father, mother, sister, whatever, it comes in the cruelty. Not giving money to the wife for her daily expenses is also a part of cruelty. Physical, obviously, if one of the spouse beats another spouse, is a clear-cut case of cruelty. So cruelty is one of the most important ground in Indian divorce system. Another ground available to the spouses for divorce is that either of the spouse has deserted his or a spouse for a continuous period of not less than 2 years. Desertion, he or she is living away from the matrimonial home despite several requests. He or she is not ready to live in the matrimonial home. So this is one of the ground of divorce. Either of the person has ceased to be a Hindu is also one of the ground of divorce. Now, after the solemnization of marriage, it is discovered that either of the spouse is suffering from incurably of unsound mind. That he is of unsound mind which is not curable. Then this is the ground of divorce. Either of the spouse is suffering from incurable form of leprosy, which is in a communicable form. It transmits the virus from one to another, then this is also one of the ground of divorce. Either of the spouse, if suffering from some vulnerable disease which is in communicable form, incurable form of vulnerable disease, then this is also one of the ground of divorce. Or one of the spouses renounced the world. Renounce the world means he has become sand or something like that. So this is one of the ground of divorce. If either party has not been heard or seen alive for a continuous period of 7 years. Now, this is also one of the ground of the divorce, because under Indian evidence system, if a person is not heard of or seen alive, then he is considered to be dead. There's so many grounds, like you just cannot remember one. So I'm just for correct interpretation, I'm just referring the book on it. I think I have covered everything in this topic, and no more thing has remained. Now, today we have talked upon divorce. In the next session, we talk about what will happen after divorce, what will happen about maintenance, what will happen about permanent alimony and other things. So friends, please give your comments. How did you like this session? And thank you so much.